The Supreme Court rejects multiple abortion-related cases and sends them to the federal courts instead, after reversing Louisiana's pro-life law last week. The Supreme Court last week instructed federal courts to reconsider 2 Indiana abortion laws and 2 buffer zone laws. One Indiana abortion law requires parental consent for minors seeking abortion, and the other that mothers receive an ultrasound. The federal courts originally halted these laws, but will now look at them again. Also last week, the Supreme Court said in a written order it would not hear cases from Chicago, Illinois, and Harrisburg, Pennsylvania, where pro-lifers have challenged buffer zone restrictions outside of abortion facilities. These orders came the same week the Supreme Court reversed Louisiana's pro-life law, which required abortion facilities maintain the same safety and health standards as all other surgical centers. Prudence Robertson, communications associate for the Susan B. Anthony list, joins us now via Skype for pro-life analysis. Prudence, welcome. First off, can you give us a quick overview of these 2 Indiana pro-life laws the federal courts will now reconsider?
Of course. So the first is an ultrasound law, and it allows women to view their unborn baby growing inside of them via ultrasound. And, you know, for women, this is so important because the ultrasound often reinforces the humanity of the unborn child and moves a mother to choose life. So, you know, we're in full support of those ultrasound laws. And the second law that the Supreme Court sent back to the 7th Circuit is a parental consent law, which allows parents the ability to protect their young daughters who are minors from the abortion industry when they might be considering an abortion. It includes parents in that conversation that is life-altering and protects young girls from the abortion industry that preys upon them time and again. So these are compassionate, important laws that should stand.
Prudence, what action then do you expect from the federal courts here in light of the Supreme Court's ruling against Louisiana's pro-life law last week?
Right. So, of course, we're very disappointed with that ruling, striking down Louisiana's law that protects women and unborn children from the abortion industry that refuses to regulate itself. Now, the 7th Circuit ruled these Indiana laws to be unconstitutional because they pose an undue burden on women seeking an abortion, and that was a precedent founded in Roe versus Wade. But we're encouraged that the Supreme Court has now sent those rulings back to the 7th Circuit and ask the federal court to take another look, because what that signals to us is that the Supreme Court may have come to a different decision, you know, that these laws might not cause an undue burden. And you know, Catherine, very well, as much as I do, that they don't pose an undue burden. They protect women from the abortion industry and inform them about what abortion is. So we're encouraged with this. And Clarence Thomas, in his concurring opinion in the Louisiana case, made clear that the abortion precedents found in Roe versus Wade are not constitutional, that they are creations that should be undone. So we hope that the 7th Circuit takes heed of Justice Thomas's words and really takes a closer look at these decisions and rules to uphold these important laws.
So that is encouraging insight. And Prudence, the Supreme Court also refused to take on buffer zone cases. Can you explain how these buffer zone laws impact the work of the pro-life movement?
Absolutely. So buffer zones, they restrict the pro-life speech of Americans who are working to speak the truth in love to women who are at the door of the abortion facility. You know, they're about to go in and have an abortion. And as someone who has grown up prayerfully protesting and being a part of the sidewalk counseling mission, it's so important to not have these buffer zones, because we need to be able to get to these women to give them the facts about abortion. There are so many cases where women have chosen life for their babies right there at the door because pro-lifers are there sharing with them the truth. So we hope that you know, these buffer zones are taken away so that we can continue to work on this front line to protect the unborn.
Absolutely. And finally, Prudence, what does it reveal, though, that the Supreme Court is punting on all of these cases? Does this mean they don't want to consider another abortion-related case?
No, I think that the fact that these SCOTUS rulings that they've been punting these cases, what it really shows is that abortion law is not settled in America and that it needs to change. And across the states, we're seeing pro-life laws being passed in numbers that we never have before. In Tennessee, they just passed a landmark law that has strong pro-life protections for unborn babies as early as you can hear their heartbeat. And in Mississippi, they just passed a law banning discriminatory abortions based on race or sex or a disability diagnosis. So the courts really need to get in line with the court of public opinion, which is overwhelmingly moving towards life. And I would also just say that this Supreme Court, based on these recent rulings that we've seen on the abortion issue, has shown us just how unpredictable the Supreme Court is right now. And that has shown the pro-life movement that now more than ever, we need conservative justices on the court. And that's why groups like Susan B. Anthony List are working so hard to reelect President Trump and the pro-life Senate majority. A Gallup poll came out today showing that 1 in 3 Americans consider abortion to be a key issue in who they will vote for in November. So we're working hard to turn out every persuadable pro-life vote so that President Trump can continue to transform the courts and especially the Supreme Court. It's so important.
Yes.
This is a matter of life or death.
We'll continue to keep our eye on the Supreme Court. Absolutely. Prudence Robertson, Communications Associate for the Susan B. Anthony List. Thank you.
Thanks, Catherine.